This is HOA catastrophe. It started as a rumor and ended as a case file. You just earned yourself a fee. That was the first thing Janet Turner said to me when I pulled into my assigned spot at Magnolia Heights Community Association in Park City, Utah, holding my bank receipt showing I had paid the monthly dues 3 days early. She was standing next to my car door before I even got out, waving a laminated policy sheet in one hand and jabbing her finger at my windshield with the other. Her badge clip caught the sunlight, and her pink bucket hat sat crooked on her head like she had rushed over the second she saw me turn in. I am an appliance repair tech, and I had just finished a 12-hour shift fixing a commercial freezer across town. My phone was still in my hand because I had been updating my dispatch queue, and my blue work shirt was soaked through with sweat from crawling behind restaurant equipment all afternoon. Janet did not care. She told me my bank receipt did not matter, only her ledger did, and she was logging me as delinquent for the second time this year. I looked at the receipt on my phone screen, then at her face. "The rules do not care about your excuses, and neither do I," she said, and she turned on her heel and walked back toward the mailbox cluster without waiting for me to respond. I stood there in the heat, my bucket hat doing nothing to block the glare, and I felt something click in my head. This was not the first time Janet had pulled this move. 6 months ago, a neighbor told me they had paid a fine years back just to make Janet stop harassing them. And now they regretted it, because the whole thing never made sense. The neighbor said the violation notice had appeared on their door one morning with no warning, no hearing, and no way to appeal without going through Janet first. They paid $200 to avoid a lien threat, and the receipt they got back was handwritten on a generic invoice pad. I had filed that story away as neighborhood gossip, but now it was happening to me, and the pieces were starting to line up. Janet had been the gate access administrator for Magnolia Heights for nearly a decade, and she ran the system like it was a classified government operation. The development micromanaged everything and called it standards. Every rule had a subrule, and every subrule had an exception that Janet controlled. If you wanted a guest parking code, you went through Janet. If you needed to contest a violation, you went through Janet. If you had a question about why your dues were marked late, even though you had proof of payment, you went through Janet, and she would tell you the ledger was law and your proof was irrelevant. The HOA board backed her every time because she kept meticulous records, or at least that was the story. What nobody seemed to notice was that Janet's records were the only records anyone ever saw. I went inside and pulled up my bank statement on my laptop. The payment had cleared on the 27th of last month, 3 days before the due date. I took a screenshot, saved it to a folder, and opened my email to send a polite correction to the HOA management company. Before I hit send, I paused. If Janet was doing this to me now, and she had done it to my neighbor before, how many other people had she done it to? I opened the neighborhood group chat and scrolled back through 6 months of messages. There were at least 4 separate threads where residents complained about being marked delinquent despite having proof of payment, and in every case, Janet had responded with the same line: "The ledger does not lie, and if you want to dispute it, you need to submit a formal request in writing within 10 business days, or the fee stands." Nobody ever followed up in the chat after that, which meant either they paid the fee, or they fought it privately and lost. I needed to know if this was a pattern or just bad record keeping. I called the management company and asked for a copy of my account history going back 2 years. The woman on the phone said she would email it within 3 business days, and she sounded annoyed that I was asking. I thanked her and hung up. Then I sat at my kitchen table and stared at the bright orange violation door hanger that had appeared on my door that morning. It was the 3rd one this month, and each time it had accused me of a different infraction: parking in the wrong spot, leaving my trash bin out past collection hours. And now, this delinquent dues claim. None of the violations had included a photo, a timestamp, or a witness signature. They were all printed on the same generic template with Janet's name stamped at the bottom, and a line that said failure to comply within 5 business days will result in additional penalties, including towing and legal action. I decided to dig into the cold case my neighbor had mentioned. I knocked on their door that evening and asked if they still had any paperwork from the fine they paid years ago. They looked nervous, like I was asking them to testify in court, But eventually they pulled out a manila folder with a handwritten receipt and a photocopy of the original violation notice. The notice was identical to the ones I had been receiving. Same template, same vague wording, same lack of evidence. The receipt showed they had paid in cash directly to Janet, and the date stamp was smudged. I asked if they had ever received a follow-up confirmation from the management company, and they said no. They told me they had tried calling the management company to verify the charge, but the company told them all fines were processed through the HOA directly, and they should contact Janet if they had questions. So they did, and Janet told them the case was closed and no refunds were available. I took photos of everything with my phone and thanked them. They asked me not to mention their name if I went public with this, because they were terrified of retaliation and refused to be seen on camera at first. I promised I would keep them out of it unless I had no other choice. That night, I started building a spreadsheet. I listed every violation notice I had received, every delinquent dues claim, and every interaction with Janet where she had moved the goalposts or changed the rules mid-conversation. I included dates, times, and exact quotes as best as I could remember. Then I added my neighbor's case as a reference point and started looking for other victims in the group chat archives. By the end of the week, I had found 8 more residents who had mentioned similar issues in passing, and I reached out to each of them privately. 3 responded. 2 of them had paid fines to avoid towing threats, and 1 had gone to small claims court and lost because Janet showed up with a binder full of notices, and the judge ruled that the HOA had followed its own procedures. That last detail stuck with me. Janet's binder was always full, always organized, and always impossible to verify because nobody else had access to the original records. The management company only saw what Janet sent them, and the board only reviewed what Janet prepared for meetings. If Janet was altering notices or backdating entries, there was no independent check to catch her. I needed evidence that would hold up outside of a group chat, so I installed a doorbell camera on my front door and set it to save clips to the cloud automatically. I also started keeping a log of every time Janet approached me, every time a notice appeared, and every time I submitted proof that contradicted her claims. The next violation notice showed up 2 days later, and this time it accused me of having an unauthorized vehicle parked in my second spot. I did not have a second vehicle. I checked the doorbell footage and saw Janet walking up to my door at 6 in the morning, slapping the notice on the frame, and walking away without knocking or leaving any other documentation. I saved the clip, downloaded it, and added it to my evidence folder. If you are enjoying this HOA cold case investigation, hit that like button and subscribe for more neighborhood drama where the evidence wins. Janet escalated 2 weeks later with a surprise inspection stunt where she showed up with a clipboard like it was a crime scene. I was in my driveway, unloading tools from my van after a morning service call when she walked up with a tape measure and started measuring the distance between my trash bin and the curb. She did not say hello. She did not explain what she was doing. She just crouched down, stretched the tape, and wrote something on her clipboard. I asked what this was about, and she told me I was in violation of the bin placement ordinance, which required all trash receptacles to be stored at least 18 inches from the curb when not in use. I looked at my bin. It was maybe 16 inches away. I told her I would move it, and she said it was too late. The violation was already logged, and I would receive a formal notice within 24 hours. I moved the bin immediately. Then I went inside and pulled up the HOA rulebook on my laptop. The bin placement rule existed, but the wording said receptacles should be stored a reasonable distance from the curb to avoid obstructing pedestrian or vehicle traffic. There was no 18-inch minimum. I took a screenshot of the rule and emailed it to Janet with a polite note saying I had reviewed the policy and I believed my bin had been in compliance. She responded within an hour. Her email said the 18-inch standard was an internal operational guideline adopted by the board at a closed session last year, and it superseded the general rulebook wording. She did not provide minutes from that session. She did not provide a copy of the guideline. She just said it was policy, and I was in violation. That was the first goalpost move I could document in writing, and it was exactly the kind of thing that would matter later. I forwarded her email to the management company and asked them to confirm whether the 18-inch rule was official policy. They never responded. The violation notice appeared on my door the next morning, and it included a $50 fine with a deadline of 5 business days. I paid it under protest and kept the receipt because my car was needed for a strict work shift and a tow threat could get me fired. I could not afford to have my vehicle impounded over a trash bin dispute, and Janet knew it. The rage was building, but I kept it controlled. I did not confront her. I did not post about it in the group chat. I just kept gathering evidence and waiting for the right moment. That moment came faster than I expected when I received a certified letter from the HOA attorney threatening a frivolous small claims filing meant to force me into court and waste time. The letter accused me of chronic non-compliance and listed 6 separate violations over the past 3 months, including 2 I had never received notices for, and 1 that had supposedly occurred on a day I was out of state for work. The letter said the HOA was prepared to pursue a lien on my property if I did not pay the accumulated fines, which now totaled $850 within 10 business days. I called the attorney's office and got a paralegal who sounded bored. I explained that half the violations listed in the letter were either incorrect or never delivered to me, and I had proof. She told me to submit my evidence in writing to the HOA board, and if they agreed to review it, they would notify me of a hearing date. I asked how I was supposed to submit evidence to the board when the only point of contact was Janet, the same person who had issued the violations. The paralegal paused, then told me that was an internal HOA matter and I should consult the bylaws. She hung up. I pulled up the bylaws and found the section on dispute resolution. It said any resident accused of a violation had the right to request a hearing before the board, and the request had to be submitted in writing to the HOA secretary within 10 business days of receiving the notice. The problem was that Janet was the HOA secretary. She had held that position for 8 years, and she was the gatekeeper for every formal process in the association. If I wanted a hearing, I had to go through her, and she could delay or deny my request with no oversight. I decided to bypass her. I looked up the president of the HOA board, a retired dentist named Mark, and I called him directly. He sounded surprised to hear from me, and he listened politely while I explained the situation. I told him about the delinquent dues claim, the trash bin measurement stunt, the certified letter, and the fact that I had proof contradicting at least 4 of the 6 violations listed. He said he was not aware of any chronic compliance issues in my unit, and he would look into it. Then he said something that made my blood run cold. He told me that Janet handled all the operational compliance tracking, and the board relied on her reports because she was meticulous and had never given them a reason to doubt her. I thanked him and hung up, and I realized that Janet's power came from the fact that nobody checked her work. The board trusted her, the management company deferred to her, and the residents were too scared or too tired to fight back. If I was going to beat her, I needed to force an independent review of her records, and I needed to do it in a way that she could not block or manipulate. I started pulling everything together. I had my bank statements showing on-time payments. I had doorbell footage showing Janet delivering notices without proper documentation. I had email exchanges showing her moving the goalposts and inventing rules. I had testimonies from 3 other residents who had been targeted the same way, and I had my neighbor's old case file showing a pattern that went back years. But I still needed the smoking gun, the one piece of evidence that would prove Janet was not just incompetent, but actively running a scheme. That piece fell into my lap when I went to the tow yard to check on a separate issue. I had been told by another neighbor that their car had been towed from a guest spot without warning, and they had to pay $300 to get it back. They said the tow company claimed the HOA had authorized the tow, but when they called Janet to complain, she told them the guest spot was restricted and they should have known better. I asked the neighbor for the tow company name, and I drove over to their lot to ask some questions. The clerk at the tow yard was a guy in his 20s who looked like he was tired of dealing with HOA drama. I told him I was a resident at Magnolia Heights, and I wanted to verify whether the HOA had a contract with his company. He pulled up the account on his computer and said yes, they had a standing agreement to tow unauthorized vehicles on request. I asked how the requests were submitted, and he said they came in through a phone line that was answered by the HOA contact, which was Janet. I asked if there was any paperwork or authorization required before a tow, and he said no. The HOA contact just called and gave them a spot number and a vehicle description. and they dispatched a truck. I asked if I could get a copy of the call log showing when Janet had requested tows over the past year. The clerk hesitated, then said he was not supposed to give that out without a subpoena or a formal request from the HOA. I told him I was preparing a dispute and I needed the records to verify whether the tows were legitimate. He thought about it for a second, then said he could not print the logs, but he could tell me that the tow yard clerk who quietly admits the HOA paperwork is sloppy had once mentioned to him that some of the tow requests from Magnolia Heights did not match up with the violations the residents said they received. He said it was not his problem, but if I wanted to file a formal complaint, I should talk to the tow company manager. I thanked him and left, but that conversation confirmed what I had suspected. Janet had a cozy relationship with the tow vendor, and the call logs would show it. If I could get those logs, I could prove that she was authorizing tows without proper notice or board approval, and that would open the door to an audit of her entire operation. I went home and started drafting a formal records request to the management company. I asked for copies of all violation notices issued to my unit over the past 2 years, all payment records, all tow authorizations, and all board meeting minutes where my name or unit number had been mentioned. I sent the request via certified mail and kept a copy for my files. The management company had 30 days to respond under Utah law, and I was betting that when they pulled the records, they would find discrepancies between what Janet had reported and what actually happened. While I waited, I kept building my case. I went back to the neighbor who had told me about the old fine they paid, and I asked if they would be willing to sign a written statement describing what happened. They were still nervous, but after I explained that I had proof of a pattern and I was not going to mention their name publicly unless they agreed, they said yes. I drafted a short statement laying out the facts, the violation notice with no photo or timestamp, the cash payment made directly to Janet, the lack of follow-up from the management company, and the refusal to issue a refund. They signed it and dated it, and I added it to my binder. I also started documenting every interaction I had with Janet going forward. I bought a small voice recorder and kept it in my pocket whenever I was outside, just in case she approached me again. I was not going to let her catch me off guard or twist my words later. 2 days before the management company records were due, Janet showed up at my door unannounced. She said she had received my records request, and she wanted to discuss it in person before the company wasted time pulling files. I told her I was happy to discuss it, but I wanted to record the conversation for my records. She said no, that was not necessary, and if I did not want to cooperate, she would assume I was acting in bad faith, and she would recommend the board move forward with the lien. I told her I was not acting in bad faith. I was exercising my legal right to access records, and if she had a problem with that, she could take it up with the management company. She stared at me for a long moment. Then she turned and walked away without another word. I closed the door and immediately wrote down everything she had said, including her threat to recommend a lien. That was intimidation, and it was going in the binder. The records arrived 3 days later, and they were a mess. The management company had sent me a PDF with 2 years of account activity, but half the entries did not match the notices I had received. There were 3 delinquent dues charges that I had never been told about, 2 of which had supposedly been resolved by payments I never made. There were 4 violation fines listed with dates that did not align with the notices on my door, and there was a note in the file saying that all compliance actions were processed through the HOA secretary, and the management company did not independently verify them before adding them to resident accounts. That was the confirmation I needed. Janet was entering charges into the system without oversight, and the management company was rubber stamping them. I cross-referenced the account activity with my bank statements and found 2 payments that I had made which were not credited to my account. Instead, they were marked as unallocated funds and held in a suspense account. I called the management company and asked why my payments were not applied, and the woman on the phone said she did not know. I would have to contact the HOA secretary to resolve it. I hung up and added that call to my log. Then I opened my evidence binder and started organizing everything chronologically. I had notices, emails, bank statements, doorbell footage, testimonies, account records, and now proof that payments were being misallocated. The pattern was clear. Janet was using her position to create violations, demand payments, and pocket or redirect funds in ways that were never audited. The question was how to prove the last part, because without a smoking gun showing where the money went, the board could argue it was just sloppy bookkeeping. That smoking gun came from an unexpected source. One of the residents I had interviewed mentioned that they had once seen Janet having lunch with the owner of the tow company, and they thought it was odd, because the owner was not a resident of Magnolia Heights. I asked if they remembered when or where, and they said it was about 6 months ago at a diner in town. I did not have a way to prove the meeting happened, but it made me think about the tow company relationship in a new light. If Janet was getting kickbacks from the tow vendor, there would be a financial trail, and the best way to find it was to look at the HOA's vendor payments. I submitted a second records request, this time asking for copies of all vendor contracts and payment records for the past 3 years. The management company pushed back and said that vendor records were not resident records, and I did not have a right to access them without board approval. I responded with a letter citing Utah statute and pointing out that HOA financial records are subject to member inspection, and vendor payments are financial records. They grudgingly agreed to provide the records within 30 days, but they said they would need board approval to release them. 2 weeks later, I got a call from Mark, the board president. He said the board had discussed my request at a closed meeting, and they were concerned about the volume of records I was asking for and the accusations I was making. He said Janet had presented her side of the story, and she claimed I was harassing her and making false allegations to avoid paying legitimate fines. He said the board was willing to offer me a settlement if I dropped the records requests and paid the outstanding fines. They would waive any future penalties and consider the matter closed. I told him I was not interested in a settlement because I had proof that the fines were fraudulent and I wanted an independent audit of Janet's records. He sighed and said that was not going to happen because the board had reviewed Janet's files and everything was in order. I asked if the board had cross-referenced her files with the management company records, and he said no, they had not seen a need to. I told him that was the problem, and I was going to keep pushing until someone did the cross-reference. He said that was my right, but I should be prepared for the possibility that the board would move forward with the lien if I did not pay the fines by the deadline. I hung up and realized I was running out of time. The lien deadline was 10 days away, and if the board filed it, I would have to go to court to get it removed, which would cost money and time I did not have. I needed to force the issue now, and the only way to do that was to go over the board's head and take my evidence to someone who had the authority to investigate. I called the HOA attorney's office again and asked to speak to the lawyer directly. I got a voicemail and left a message explaining that I had evidence of financial improprieties in the HOA's compliance enforcement process, and I wanted to schedule a meeting to present it before the board moved forward with a lien. The lawyer called me back the next day and agreed to meet, but he said he represented the HOA, not me, and anything I told him could be shared with the board. I said I understood, and I scheduled the meeting for the following week. I spent the next few days preparing. I printed out every document in my evidence folder and organized them into a second binder, this one with colored tabs marking each section: delinquent dues, violation notices, payment misallocations, tow authorizations, and vendor relationships. I practiced walking through the timeline and explaining how each piece connected to the others. I kept my plan quiet, because the HOA depends on controlling the narrative, and I wanted to catch them off guard. The meeting was scheduled for 2 p.m. at the attorney's office, which was in a professional building downtown. I took a half day off work and drove over with both binders in a bag. When I arrived, the receptionist told me the attorney was running late and I should wait in the lobby. I sat down and checked my phone. Janet had sent me an email an hour earlier saying she had heard I was meeting with the attorney, and she wanted to remind me that making false accusations could result in legal action against me personally. I did not respond. I just saved the email and added it to the intimidation section of my binder. The attorney finally called me in 20 minutes later. His office was small and cluttered with case files, and he looked tired. I introduced myself and laid both binders on his desk. I told him I had documentation showing a pattern of fraudulent violations, payment misallocations, and potential kickbacks involving the HOA secretary and a tow vendor. He leaned back in his chair and said that was a serious allegation, and I would need to have solid proof before he could take it to the board. I opened the first binder and walked him through the timeline. I showed him my bank statements proving on-time payments, the management company records showing those payments were not credited, and Janet's emails claiming I was delinquent. I showed him the doorbell footage of her delivering notices without documentation. I showed him the violation for the trash bin in her email inventing an 18-inch rule that did not exist in the bylaws. I showed him the certified letter threatening a lien based on violations I had never received. And then I showed him the tow yard clerk's statement and the pattern of tow authorizations that did not match resident reports. The attorney flipped through the document slowly, and I could see his expression change. He asked if I had submitted any of this to the board, and I said I had tried, but all requests went through Janet, and she was stonewalling me. He asked if I had contacted the management company, and I said yes, and they had told me to work with the HOA. He closed the binder and looked at me. He said this was enough to warrant an independent review, and he would recommend the board hire a third-party auditor to examine Janet's records. He also said that if the audit found evidence of fraud, the board would be obligated to report it and take corrective action. I asked how long that would take, and he said at least 60 days, maybe longer. I told him I did not have 60 days, because the lien deadline was in 8 days and I could not afford to have my property tied up while they investigated. He said he would ask the board to suspend enforcement actions pending the audit, but he could not guarantee they would agree. I thanked him and left, feeling both relieved and frustrated. I had gotten the audit moving, but Janet still had 8 days to do more damage. She did not waste them. 2 days later, I came home from work to find a bright orange violation door hanger on my door, accusing me of operating a commercial vehicle in a residential zone. My work van was parked in my assigned spot, the same spot I had been using for 2 years. I checked the bylaws and found the section on vehicles. It said commercial vehicles over a certain weight were restricted, but my van was under the limit. I measured it, took photos, and emailed the proof to Janet. She responded within an hour saying the weight limit had been revised at a recent board meeting, and my van was now in violation. She said I had 24 hours to remove it, or it would be towed. I called the attorney and told him what was happening. He said he would contact the board president and try to stop the tow, but he advised me to move the van just in case. I did not want to give in, but I also could not risk losing my vehicle right before a work shift, so I moved the van to a friend's driveway and documented everything. The next morning, Janet sent me an email saying the violation had been resolved because I had complied, but the fine still stood because I had been in violation for more than 24 hours. The fee was $150, and it was due in 5 business days. That was the moment I decided to stop playing defense. I had enough evidence to prove Janet was running a scheme, and I was not going to wait for the audit to finish before I used it. I called the 3 residents I had interviewed and asked if they would be willing to attend a board meeting with me and present their cases publicly. 2 of them agreed. The third was still too scared, but they said they would submit a written statement if I needed it. I checked the HOA website for the next board meeting date. It was scheduled for the following Thursday at 7 p.m. in the clubhouse. The agenda was posted online, and there was a section for resident comments at the end. I emailed the board secretary, which was Janet, and requested to be added to the comment list. She did not respond. I sent a follow-up email the next day, copying the board president and the attorney. Janet finally replied and said the comment list was full, but I could submit written comments if I wanted. I responded and said I was exercising my right under the bylaws to address the board in person, and if she refused to add me to the agenda, I would show up anyway and demand to be heard. The meeting was the first set piece, and I arrived early with both binders in hand. The clubhouse was a small room with folding chairs arranged in rows and a table at the front for the board members. There were about 15 residents already seated, most of them looking bored or annoyed. Janet was at the front table setting up her laptop, and she did not look at me when I walked in. I sat in the second row and placed my binders on my lap. The 2 residents who had agreed to come with me arrived a few minutes later and sat on either side of me. The meeting started on time. The board president ran through the standard agenda items, budget updates, landscaping bids, pool maintenance schedules. Nobody in the room seemed to care. When he got to the resident comment section, he asked if anyone had signed up. Janet said no. I stood up and said I had requested to be added and I was here to speak. The president looked surprised, and he glanced at Janet. She said she had not received my request in time to add me to the agenda, and the comment period was already full. I pulled out my phone and showed him the email chain proving I had requested to speak 3 days earlier. He sighed and said he would allow me to comment, but I had 3 minutes. I walked to the front of the room and placed one binder on the table in front of the board. I kept the other one in my hand. I introduced myself and said I was there to present evidence of financial improprieties in the HOA's compliance enforcement process. Janet interrupted and said this was not the appropriate forum for personal grievances, and I should submit my concerns in writing. I ignored her and kept talking. I said I had documentation showing that violations were being issued without proper notice, payments were being misallocated, and tow authorizations were being made without board approval. Janet stood up and said I was out of order, and the board did not have to listen to baseless accusations. The president told her to sit down, and he asked me to continue. I opened the binder and showed them the bank statements, the management company records, and the doorbell footage. I explained the trash bin stunt and the email where Janet invented a rule that did not exist. I showed them the violation for the commercial vehicle and the evidence that my van was under the weight limit. And then I showed them the tow yard clerk's statement and the pattern of tow requests that did not match resident reports. The room was silent. One of the board members, a woman in her 60s, asked if I had reported this to the management company. I said yes, and they had told me to work with the HOA. Another board member asked if I had any proof that Janet was benefiting financially from the tow company relationship. I said I did not have direct proof yet, but I had submitted a records request for vendor payments, and I expected the audit the attorney had recommended would uncover it. Janet stood up again, her face red, and she said I was making defamatory statements and she would be consulting her own attorney. The president told her to sit down again, and he said the board would review the evidence I had provided and discuss it in executive session. He thanked me for my time and said the comment period was closed. I stayed standing and said I had 2 other residents who wanted to speak, and they had similar cases. The president hesitated. Then he said they could each have 2 minutes. The first resident stood up and described the violation they had received years ago, the cash payment they made to Janet, and the lack of follow-up from the management company. The second resident described a tow incident where their guest's car was removed without warning and they had to pay $300 to get it back. Both of them said they had been too intimidated to fight back at the time, but they were willing to testify now if the board ordered an investigation. Janet tried to cut in again, and this time the president raised his voice and told her to be quiet or she would be removed from the meeting. She sat down, and I could see her hands shaking. The president said the board would schedule an emergency executive session to review the evidence, and they would notify all affected residents of their findings within 30 days. He adjourned the meeting, and the room emptied quickly. I stayed behind and collected my binders. Janet walked past me on her way out, and she leaned in close and whispered, "I do not need proof. I have paperwork and vibes." I did not respond. I just smiled and walked out. The next morning, the attorney called me and said the board had held an emergency session overnight, and they had voted to suspend all enforcement actions against me pending the audit. He also said they had placed Janet on administrative leave and assigned an interim compliance officer to handle day-to-day operations. I asked if that meant the lien was canceled, and he said yes. All pending actions were on hold. I thanked him and hung up, feeling the first real relief I had felt in months. But I was not done yet. I still needed to prove the kickback scheme, and I knew Janet would fight back if she had the chance. I went back to the tow yard and asked to speak to the manager. I explained that I was involved in an HOA dispute and I needed to verify whether the tow company had any financial relationship with the HOA secretary beyond the standard contract. The manager was hesitant at first, but when I mentioned that the HOA attorney was conducting an audit and the tow company might be subpoenaed for records, he agreed to pull the account history. He came back with a printout showing 3 years of tow requests from Magnolia Heights. I scanned the list and saw a pattern immediately. About 30% of the tows had been requested outside of normal business hours, and almost all of them had been authorized by Janet personally. More importantly, there was a note in the file saying that the tow company had a referral agreement with Janet where she received a $50 payment for every tow she authorized. The manager said it was a standard industry practice, but he admitted it could be a conflict of interest if she was also the one deciding which vehicles to tow. I asked for a copy of the referral agreement, and he said he could not provide it without a subpoena. I told him the audit was already underway, and the agreement would come out eventually, so he might as well cooperate now. He thought about it, then he printed a copy and handed it to me. I thanked him and left, knowing I had just found the smoking gun. I took the referral agreement straight to the attorney's office and handed it to him without saying a word. He read it, then he looked up at me and said this was exactly what he needed to recommend criminal charges. He said he would forward it to the board and the county prosecutor, and he would advise the board to terminate Janet immediately and refund all affected residents. I asked how long that would take, and he said the board could vote as early as the next meeting, which was in 2 weeks. I did not want to wait 2 weeks. I wanted Janet gone now, and I wanted everyone in the neighborhood to know what she had done. I called a friend who worked in local news and asked if they would be interested in covering a story about HOA corruption. They said yes, and they sent a reporter to interview me the next day. I gave them copies of the evidence binder, the referral agreement, and the testimonies from the other residents. The story ran 3 days later, and it included interviews with the tow company manager, the HOA attorney, and 2 of the board members. The headline was HOA secretary accused of running kickback scheme with tow vendor, and it included photos of the violation notices, the referral agreement, and a blurred-out image of Janet's face. The story went viral in the local community, and within 24 hours, the board had scheduled an emergency meeting to vote on Janet's termination. I attended the meeting with both binders and a dozen other residents who had been targeted by Janet over the years. The board voted unanimously to terminate her, to refund all fines she had issued over the past 3 years, and to hire an independent auditor to review all HOA finances. They also voted to ban her from all HOA property, and to issue a no-contact directive prohibiting her from communicating with any resident except through an attorney. The second set piece came 2 weeks later, when I had to appear at a courthouse hallway right before a hearing on a workday. Janet had filed a defamation lawsuit against me personally, claiming I had damaged her reputation and caused her to lose her job. The hearing was scheduled for 10 in the morning, and I had to take a full day off work to attend. I showed up with my attorney, both evidence binders, and a printed copy of the news article. Janet was already there with her attorney, and she refused to make eye contact with me. The judge called us into the courtroom and asked Janet's attorney to present his case. He argued that I had made false statements about his client and that the news article had caused irreparable harm to her reputation. My attorney responded by presenting the evidence binders and walking the judge through the timeline. He showed the bank statements, the doorbell footage, the referral agreement, and the testimonies from the other residents. He also presented the board's termination letter and the no-contact directive as proof that the HOA itself had found Janet's conduct unacceptable. The judge reviewed the evidence for about 10 minutes. Then he looked at Janet and asked if she had any response. Her attorney tried to argue that the evidence was circumstantial and did not prove intent, but the judge cut him off and said the referral agreement was direct evidence of a financial conflict of interest. He dismissed the defamation lawsuit with prejudice and ordered Janet to pay my attorney fees. As we walked out of the courtroom, Janet's phone died mid-rant, and she froze in place, staring at the blank screen like it had betrayed her. That was the funny karma moment, and it felt perfect. The HOA retracts the enforcement action in writing the following week, and I received a formal letter from the board apologizing for the violations and confirming that all fines had been refunded to my account. Janet gets placed on a no-contact directive by management, and the board issued a policy clarification that destroys her favorite tactic. All violations now required photographic evidence, a timestamp, and board approval before a fine could be issued. The independent audit found improper fees tied to notices, and the HOA was forced to refund a large batch of charges across the neighborhood, totaling over $40,000. The payback came in the form of a policy clarification that destroyed Karen's favorite tactic, and the whole neighborhood celebrated when the refund checks started arriving. I kept my evidence binders in a box in my closet just in case Janet ever tried to come back, but she never did. The last I heard, she had moved out of state and was no longer involved in any HOA work. The board hired a new compliance officer who actually followed the rules, and the neighborhood group chat became a much quieter place. I still get the occasional bright orange violation door hanger, but now they come with photos, timestamps, and a clear appeals process. I have not had to use my doorbell camera footage since, but I keep it running just in case. And every time I see a tow truck in the neighborhood, I check to make sure it is not the same company Janet used, because I know exactly how that scam works now. Thanks for watching, and I will catch you in the next one.